demonstrate that the application falls within the two categories mentioned in Article 165(3). That is, there must be an alleged violation or denial or infringement or threat to the Bill of Rights. And secondly, and if I'm speaking broadly, the second category is that it must respect, the question must be in respect of the interpretation of the Constitution. Looking at the motion, and there's notice of motion and the to that extent, my lord, you need not concern yourself with the question as to whether the matter is complex or whether it brings a novel issue or whether the question is moot. Those considerations, or because it raises a matter of public interest, those considerations can only come to play if the applicant can demonstrate that there has been a denial or violation of the Bill of Rights, or there's a question of interpretation of the Constitution. Now, my lord, if you look at the motion itself and the supporting affidavit, the question, the substantial question is not brought out, it's not crystallized in the motion. And all that the applicant was doing is go through the pleadings. It is important to mention that actually the applicant doesn't have a claim, but he was going through the pleadings to try and bring out issues contained in the pleadings. But for such an application to find favor with the court, the litigant must crystallize the substantial question. So as you make that decision, it's clear that what is the substantial question of law involved in relation to Article 165, 3 and 4. And my lord, again, looking at the application, one of the issues that is being brought out in the affidavit, which I find rather worrying, is a backdoor application for your recusal. That's what I can say. It's challenging the integrity of this court. And if I may read out what it says,